Sir, please go ahead. Good evening to all of you. Yesterday, by oversight, we missed 2 points in the agreement of sale. One is the default on the part of the vendor and the default on the part of the vendee. Those clauses, I somehow missed it. I'm sorry for it. Here, one clause which you add is, if the vendor fails to execute and register the sale deed, the vendee is entitled to get the agreement specifically enforced together with the liquidated damages of 5 lakhs for non-performance. And the next clause which I also missed was, if the vendee fails to pay the balance of the sale consideration within the stipulated date, the advance and earnest money shall stand forfeited. But under a specific relief act, whatever monies are had and received, even though there may be a forfeiture clause, the same is refundable. Of course, you may not get specific performance, but as far as amount is concerned, it has to be returned. Those are the 2 points by oversight I missed. I'm referring to it today. Now we go to the second document, that is what is called a sale deed, or what is called in Telugu as the Vikraya Patram. Here, as far as sale deed is concerned, the same clauses which you incorporate in the agreement of sale, you incorporate it in the sale deed. Only thing is, it's a concluded contract. That's the word you say, agree to purchase, you don't mention. But you say, as this day purchased the schedule mentioned property for a total sale consideration of rupees so and so. I also referred to the Suraj Lam's case and distinguished it also from the present scenario. So the sale deed is almost a verbatim agreement of sale, but the difference being the word, we say it's a concluded contract, we say is paying a sum of rupees so and so, vendor is selling for so and so period, so and so amount, and other clauses remain as it is. But if you are purchasing agricultural land, there is a stipulation that it does not contain the trees, plants, so on and so forth. They have to be excluded, and there must be a clause regarding that, be it an agreement of sale or be it a sale deed. And one more thing is, when the document is presented for registration, what all is required is the original document along with the copy of the document, and also the plan which is drawn or scanned. Nowadays, they don't accept blueprint. You have to get it scanned on the computer and then file it. And along with that, you also file Annexure 1A, which consists of the description of the property and the square yard, so on and so forth. And then along with that, you are also supposed to submit the link documents which support the title of your vendor, and also other things also you have to file. So these are all the formalities as far as a sale deed is concerned. Now we go into the next document, the third document, called a gift settlement deed or a gift deed. What do you exactly mean by a gift settlement deed? Or in Telugu, it is called Dana Patram. Here, as far as gift settlement deed is concerned, there is no consideration at all as far as gift is concerned. It is only out of natural love and affection between persons who stand in near relation to each other, be it a mother and a son, father and a son, father and a daughter, father and a granddaughter, so on and so forth. The person who executes the gift is called the donor, and the person to whom the gift is executed is called the donee. Like a valid contract, there must be an offer of gift and there must be an acceptance of gift. That is the reason why the gift deed is always said to be a bilateral document. It has to be signed by the donor in token of having given the gift, and it should also be signed by the donee in token of having accepted the gift. Only the donor should not sign. It should be signed by both the donor and the donee. The same recitals which you mentioned in the sale deed, also the same clauses have to be mentioned, but only thing is you will have to mention the word out of natural love and affection. That is the word which we have to use. If it is between blood relations, the stamp duty which is leviable is 1% or 3%. But if the gift is given to an outsider, the stamp duty which is leviable is 5% and 1% is for registration. And gift deed is drafted in a different way. Some people call it as a gift settlement deed, and some people call it as a gift deed, ordinary gift deed. But gift settlement deed looks more attractive to look at. But one important thing you must remember is nemo dat quod non habet doctrine also applies. That is, you cannot give some other's property. You must have a present title to the property. You must have the disposing capacity as far as the property is concerned, or you must have acquired the property which you are competent to execute the sale deed. One important thing you must remember here is a Muslim cannot execute a gift deed for the simple reason under the Shariat or the personal law. Even if he executes a gift, it will be valid only to the extent of 1/3, and the other 2/3 will have to go by inheritance. And one important thing you must remember is because every document has to be supported by consideration, the consideration being natural love and affection between near relations. Sometimes what happens is in our day-to-day life, we have some affection for some outsiders. That is the reason the stamp duty that is leviable in respect of when the gift is given to an outsider, the stamp duty is more. It is 5% of the amount mentioned. Then you can say, sir, when there is no consideration, where is the question of mentioning the consideration? But please remember, there is a saying in Telugu, Devulu varamichina pujari addochadu. Government says, you people execute a document unto yourselves, but where is the government? Where is my revenue? So the revenue is in the form of stamp duty and registration charges or transfer charges, which is collected by the registrar at the time of registration, execution, and registration of the gift deed. Here, one thing is important, sir. In the Transfer of Property Act, when I deal with it, I'll tell you there are some gifts which are called onerous gifts. Onerous gifts means onerous. The word onerous means burdensome gifts or gifts coupled with liabilities. Sometimes what happens is the old man executes a gift deed, but is due and payable some amounts to the government or to the bank or to some other person. Then in that case, there is a clause normally inserted saying that it is an onerous gift and the donee has to discharge all the liabilities and the burdens which are imposed on him before he gets the property. That is called onerous gifts. What are the incidents of onerous gifts? How it is made? We will discuss it when we come to section 127 or 128 of the Transfer of Property Act, which deals with onerous gifts. Then there is one more gift called Donatio Martis Casa, DONATIO space Martis, MORTIS space Casa, CAUSA. That is a gift which is made in anticipation of death. Here, the gift that can be made in Donatio Martis Casa is what is called only movable property can be gifted under this head, not anything else. And it's also subject to a restriction that once the Donatio Martis Casa takes place, the person who has gifted the property should die immediately or later. Then only it is operative. If he does not die, or let us say the donee out of happiness, he dies before the donor, then the gift gets resumed. So these are all the incidents as far as a gift deed is concerned. The prime important, and even in a gift deed, you will have to mention the schedule of property correctly. Why I'm again dealing with this boundaries is most of the disputes which are coming to court today are because of wrong boundaries being described in the schedule. For example, suppose agricultural land is sold. Suppose you take survey number 90. Survey number 90 comprises of 300 acres of land. Out of 300 acres, 10 acres is gifted. Then the survey number subdivisions have already taken place. It is 90 by R, 90 by R, 90 by E, 90 by E, so on, so on, so on, so. So subdivisions are there. So in the schedule, when you mention, or the body of the gifted deed which you mention, you will have to mention the subdivision correctly. If you don't mention the subdivision correctly, you will be litigating throughout your life. There is no use of getting, it is a bitter pill which you take. So we have to be very, very careful. Draft it, redraft it, again make a final. Don't be in a hurry to draft a document just because the client has come to you. Take the proper instructions, look into the linked documents, look into the pahanis, look into the other documents, and then prepare the document accordingly. And also try to find out whether there has been subdivision and where the property which is gifted falls, whether it's 90 by A, 90 by AA, so on and so forth. The correct description of the property has to be given in the schedule. Just like you mention yourself as a son of so and so, age so and so, occupation so and so, resident of so and so, a property also has got a proper description. And whenever there is a subdivision, whenever there is a division there, mention the correct subdivision correctly. Suppose you don't mention it correctly, you will be litigating throughout your life. You will be fighting with the neighbor. He says it's not your land, it is my land. So avoid such scenarios occurring by mentioning the correct description. And schedule plays a very important part as far as conveyancing is concerned. And like that, even the preamble, you will have to mention it clearly how your donor has acquired the property, whether the donor has purchased it, donor has got it by gift, whether he has got it by sale, whether it's got by auction purchase, or is got by partition, or by some other mode through which he has acquired the property. That has to be clearly mentioned. Because I'm saying some of you are the advocates of banks also. When you are asked to give a legal opinion, you will have to look into the preamble, look into the Swadhina Vidam. That is how the vendor or how the donor has acquired the property, through what document has acquired the property, look into the link of the property, and then come to a proper conclusion. If you do not take these steps or precautions, what would happen is you, as a bank advocate, are compelled to reject the document. Here, I came across one scenario. What happened was I was the advocate for Karur Vaishya Bank, and I was asked to scrutinize a document of, I think, that CDR, C. Dayakar Reddy, that is CDR Hospitals. And I asked him a simple question. He said, "Sir, I'm a very big man. I've got 400 acres in Narsingi in Gandipet." Then I said, "All right, sir, you must be a big man. Sir, where are your documents?" He says, "Sir, I don't have the original documents. The original documents are lost and they are not found." Then what have you got? I only got Xerox copies. I only got certified copies. Then I told him, "Sir, I cannot give an opinion on this. I have to reject your documents." But I can. Then the financial controller of that CDR hospital came to me and said, "Sir, you know whose documents it is?" He said, It belongs to CDR." I said, "I'm not bothered with CDR or FDR or TDR. The question is, the documents are clear. I will try to clear the documents." Then I gave him one idea by saying, "Sir, you lodge an FIR or you execute an indemnity bond in favor of the bank, saying that the originals are lost and only certified copies are available. As and when the originals are traced, I will try to make it over to the bank. And better you give a paper publication also that the originals are lost and you have initiated FIR regarding the lost documents. And that's how you safeguard the interests of the bank for whom you are appearing. Please remember, today A may be the manager. Tomorrow B may be the manager. Tomorrow, unlessly dust will be thrown on you to say the advocate has been corrupt. Advocate has not gone through the documents properly and given his opinion. But please remember, earlier what happened was there is a subject called Consumer Protection Act, or what is called Viniyogadarala Chattam. In that, advocates also came under that bracket to say that if they give a false opinion or they give a wrong opinion, or if they are actuated by what is called corrupt motives, and the document opinion is not clear, please remember the then manager and the present advocate both have colluded with each other in passing the documents. Then you will be in trouble, sir. Be very, very careful. But now, of course, thanks to the Supreme Court, advocates have been removed from the consumer bracket. They do not come under the Consumer Protection Act. Likewise, I could say that, though, please remember, everything is tilted against an advocate. If you see various laws, you have got Contempt of Courts Act, you have got the Bar Councils Act, you have got the Advocates Act and all. An advocate is liable for misconduct and deficiency of service. But unfortunately, what is happening is, of course, I have no aspersions on any judge or any judiciary, sir, because some of you, I know, they are related to judges also. I don't want to make any aspersions. Suppose a court does not follow a high court judgment or does not follow a Supreme Court judgment, is not the judge liable for liability, sir? Is he not accountable for it? He is also accountable, but unfortunately, contempt applies only to advocates and not to the judiciary. So that is a misnomer, sir. Perhaps you do not know, later that may also come. So, as far as gift is concerned, you describe the person not as a vendor, but you describe a person as a donor. And the person who accepts the gift is not called the vendee, but is called the donee. And the transaction of donor and donee is put in a watertight compartment called a gift deed. So a gift deed comes from the word donatio. When one person offers the property belonging to him free of cost, gratuitously, without any consideration, out of natural love and affection, it is called a gift. And a gift also has to be attested by two witnesses. That is, attesting witnesses who must see the donor sign and the donee sign, and also the execution has to be witnessed by the attesting witnesses. It is always safer to take attesting witnesses because tomorrow, if anything happens to the donor, his legal has questioned that gift deed. The attestors will come and say, "Sir, we are acquainted with the signature of the donor, we are acquainted with the signature of the donee, and in our presence the execution was made, and after the donor and donee signed, we countersigned the document as having witnessed the execution." So, one thing please remember, unlike a sale deed, the gift deed is supposed to be a bilateral document. There must be an offer of gift and there must be acceptance of gift, and both of them in token of having offered the gift has to sign as a donor, and the person to whom the property is gifted also has to sign as donee. So in other words, donor and donee both sign the document, execute the document, and it is said to be a bilateral document. And if the signature of the donee is not there, then what is the repercussions, sir? Repercussions are it is not a gift at all. But as far as a Muslim is concerned, under the personal law of Muslims, a Muslim is entitled to orally gift away his property. That is called the Hiba, Hiba. But one thing is this, Hiba has got certain conditions. What are those conditions? One is the property which is gifted should be within the disposing capacity of the donor, number one. Number two, most important is actual, physical, symbolic, constructive possession or vacant or constructive possession has to be delivered by the donor to the donee, and the persons who are in occupation of the property, they have to be given notice that a oral gift has taken place. As far as the property is concerned, these are the basic requirements as far as a Muslim gift is concerned. It is called the Hiba Nama. As far as a Muslim is concerned, the document need not be registered, document need not be stamped, and all the incidents of a gift deed may not apply as far as the Hiba Nama is concerned. The only criteria is that the property which is gifted should be within the disposing capacity of the donor, and constructive, actual, physical, or symbolic possession of the property has to be given to the donee. And it can be also by way of an oral gift, and sometimes you can also reduce it in the form of a memorandum, but doesn't require stamping and doesn't require registration. That's the reason why the Muslims are given special preference as far as documentation is concerned. This is as far as gift is concerned, sir. Then we go to the fourth document called release deed. Release deed, or it is also called relinquishment deed. What do you mean by a release deed or a relinquishment deed? Previously, we used to have, only in Vaishyas you have it still. That is what is called HUF. HUF means Hindu Undivided Family. HUF means Hindu Undivided Family. Who is the head of the family, sir? The Karta. The head of the family is normally the father or grandfather, as the case may be. Then other people who belong to that family are all members of the Hindu Undivided Family. Suppose, let us say, just take an hypothetical case, the father has got 4 sons, and then all the sons are entitled to 1/4, 1/4, 1/4, 1/4 share. Let us just take an hypothetical case. Then in that case, what happens is, in a release deed, suppose I as one of the sons is entitled for 1/4 share. Then what I do is, I don't want that 1/4 share. My brother B, who is there, he purchases my 1/4 share, and I release my rights as far as the property is concerned to the extent of my 1/4, and then confer ownership rights over my brother B. That is called a release or it is called a relinquishment. Then in such a case, what used to happen is earlier, please remember, whenever it's an Hindu undivided family, we used to draft the document and get it typed on a 30 rupees stamp paper because it's not a conveyance, it is only what is called readjustment of rights inter the parties. It was prevalent for a very long time. But afterwards, the government woke up and said, Sir, వీళ్ళిద్దరు చేసుకుంటే నా గతి ఏంటి? Then they amended the conveyancing by saying, Sir, even a release deed or relinquishment deed can amount to conveyance because your ownership rights are to an end and the ownership rights of the person in whose favor it has been released gets commenced. So they collect about 3% or 4% as far as release deed or relinquishment deed is concerned. So, what is the effect of a release deed or a relinquishment deed, sir? That means, as and from the date of execution of a release or a register or a relinquishment deed, the rights of the releaser is to an end, and the rights of the releasee gets commenced. And please remember, as far as release deed is also concerned, it has to be signed both by the releaser and the releasee, and it has to be attested by two witnesses. And today, even a release deed has to be on a proper stamp. That is gone are those days when you could draft it on 30 rupees stamp paper. Now it is what is called, it is treated as a conveyance, and the entire conveyance duty, like 5% or 6%, is collected from you. What is the effect of release, sir? Effect of release is the right of preemption. What do you mean by preemption, sir? See, when we are four brothers, one brother has got the preferential right of acquiring the share of the other brother, and of course, some money will also be passed on. I'm not for a moment disputing it, but the question is the next brother or the other brother who wants to purchase the property has got a right of acquiring the share of the other brother by getting a relinquishment deed or a release deed executed and duly registered as per law. And release deed also is a bilateral document. It has to be signed by the releaser and also the releasee, and it has also to be attested at least by two witnesses. There is not much about a release deed to be discussed or amplified. Then the fourth document is what is called a partition deed. Please remember, under the Partition Act governing us, a partition deed need not be registered. But please remember why partition deed need not be registered, sir? Because earlier we were all owners in common, right? But by executing a partition deed, dividing the properties amongst ourselves belonging to a particular family, there is a severance of the joint status. A, B, C, and D are, let us say, are brothers. And let us say, please remember, so long as you don't get married, there's no problem. Once you get married, you get your better half. When you get your better half, normally the fiction starts, ruptures start, fights start, differences start. So many things arise, and especially more so when you get children. What happens is your wife will be torturing you, saying that how long you will be serving your brothers, how long you will be without property, how long you will be in a joint family. Please try to separate yourself, take your share, and get away from that. Then what happens is they divide the properties amongst themselves. And how you draft the document, sir? This deed of partition executed at Hyderabad on this the day of so and so, by and between. You don't say by and in favor. By and between A, son of so and so, B and B, son of so and so, C, son of so and so, D, son of so and so. Then how do you then hereinafter call the first party, hereinafter call the second party, hereinafter call the third party, hereinafter call the fourth party? Then the preamble starts. Then we say that whereas we are the sons of Mr. So-and-so and Ms. Srimati so-and-so, who was the owner and possessor of house number so-and-so in survey number so-and-so, admeasuring so-and-so square yards, situated at so-and-so place, by virtue of having purchased the property through a registered sale deed bearing document number so-and-so, dated so-and-so. Then next paragraph you say, whereas the so-and-so who was the owner and possessor of the property in order to maintain cordiality in the family and avoid ruptures and differences in future, and to maintain cordiality as divided the properties amongst the first to the fourth parties in the manner hereinafter mentioned. Then the next clause in the preamble will be, whereas the first party is allotted a portion of house number so and so, admitting so and so, situated at so and so, Secunderabad or Hyderabad, whichever it may be, towards his share. Then next one is, whereas the second party is allotted this so and so property, admitting so and so, situated at so and so. Third party is allotted so and so. Fourth party is allotted so and so. But for clarity, what you say is the first party share, whatever is been allotted, is shown in green color in the plan annexed here to. The share that is allotted to the second party is shown in red color. The share that is allotted to the third party is shown in pink color, and the fourth one is shown in some other color in the plan annexed there too. Now this deed of partition witnessed as follows. Please remember, be very, 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 very careful when you draft a partition deed. Why? Because don't try to show your knowledge, don't try to show your skill, and don't try to be too clever when you write a partition deed. You only say, whereas the first party is allotted so and so square yards in house number so and so, comprising of the ground floor, situated at so and so, so and so. Then second party is allotted shown in so this color. Then second one is the second party is allotted so and so, shown in red color. Third is the third party is allotted so and so, shown in yellow color. Then another is fourth party is allotted this particular property shown in crimson color, whatever color it may be. Then next paragraph, what you write is, the parties have taken possession over the allotted properties and they are the absolute owners as and from this day. The second party has taken possession of his allotment and he is the owner and possessor of this property. The third party has taken possession of this property and is in possession thereof as absolute owner. Then same likewise fourth party also. And then after that, one paragraph you write, as and from this day of the partition, the parties have severed their status as joint status and have become several by virtue of this partition, and they are the owners and possessors of the respective allotments that are made to them. Please don't write anything more than what is required. Then you say, the witness whereof the parties have set their hands and affixed their signatures voluntarily without any compulsion or force, after the contents were read over and explained in whichever language they understand, and then they put their signatures, and also the schedules are separately mentioned. Schedule A allotted to first party, Schedule B allotted to second party, Schedule C allotted to third party, Schedule D allotted to fourth party. Then there's a plan also annexed to it where you show the different shares in different colors. But please remember, be it a sale deed, be it a gift deed, be it a release deed, be it a partition deed, it is advisable to get the documents registered in counterparts. Why? Because normally, sir, once the partition takes place, there is no unity among the brothers. What they do is, one person says, I will keep the original. Another person says, I will keep the original. Another person says, I will keep the original. There's a fight amongst themselves. Instead of that, you can get the verbatim copying of the original document and get the counterpart also. It's not duplicate, please. It is counterpart. It's called counterpart. Counterpart is verbatim copying of the original document into 4 parts, and 1 part each is given to each one, so that tomorrow when they go for a housing loan or some loan, for personal loan or business loan, they can always deposit the document by way of collateral security or equitable mortgage and get the loan sanctioned. And please remember, whenever you go to a bank for a loan or financial aid, they don't require the original document except your parent document they require. The linked documents, you can submit it in duplicate or take certified copies of the linked documents and give it to the bank. And also the taxes, which are paid after the mutation is done in your favor by virtue of severance. So this is a safe method of avoiding quarrels and avoiding frictions and avoiding ruptures in the family. There is absolutely no hard rule that the counterpart should not be registered. The counterpart, though it may have a separate accession number, it means it's a verbatim copying of the original document, and normally the original document is retained by the elder member and the other people that the counterparts is duly signed. And also mention a clause there in the partition deed that a counterpart of the document is also executed and registered, and one copy is given to each of the four parties. So that will save you a problem, because please remember, normally the fight takes place as to who should keep the original document. To avoid that, you get the counterparts also duly registered. Then after that, I think after the execution of the partition deed, you apply for mutation, you apply for subdivision, you also ask for the taxes being assessed separately. Then suppose it is 10-3-21, 21 by A, 21 by B, 21 by C, 21 by D. There is a severance of status. From a joint status, they become a separate status. Then the question arises, sir, how much stamp duty you have to pay? You have to pay the stamp duty on the larger share which remains, or only on one share you pay the stamp duty, not on all the shares. Only one share you take it and then pay the stamp duty and get it engrossed on stamp paper and get it duly registered. Then now, of course, I told you yesterday itself, after the Telgi scam, the non-judicial stamps are not issued except 100 rupees and 50 rupees, which are available in the market. You don't get the stamp of the higher value. So the question is, you can get it typed on a 100 rupee stamp paper, and then on the reverse of it, the sub-registrar makes his endorsements and then gives you the document. But please remember, here in Telangana and Andhra, we type the document only on one side of the non-judicial stamp or the paper, because the reverse is not for you. The reverse is meant for the sub-registrar to make the endorsement. But as far as Chennai is concerned, they draft the document or they incorporate the document on both sides, including the stamp paper. That is not followed by us in the provincial cities, please. So this is as far as partition deed is concerned. Then we go to family settlement. What do you mean by family settlement? Suppose, let us say, father, mother, and 4 sons are living together. Please remember, now the joint families are gone out of vogue. Once the son gets married, he goes out of the family, or the father knocks him out. Say, nee gati nu chuskora wanted. Endukante he doesn't want to carry problems. Please remember, it is better, even if you are father also, when you get your son married, ask him to stay separately with his wife. And during festivals or during other festivities, all of you assemble and celebrate it. Why? Because you have less problems. So sometimes what happens is, this happens as family settlements mostly you find in the Vaishya community and the Kamma community. Here, in the family settlement, what happens is, there's a property belonging to the family. Then the head of the family is A or whatever it is. Then he says, this property, then the preamble, etc., everything is mentioned. Then after that, you say that this property is by virtue of this family settlement is given to A. Another property shown in B, red color is given to B. Another property shown in yellow color is given to C, and another property given shown in brown color is given to D. Then, as far as the jewels are concerned, there's always a friction in the house as far as jewels are concerned, because ladies, especially by temperament, they are more attracted towards gold and other things. As far as men are concerned, we are very, very simple in our outlook. We don't mind about our dresses, except my admin who comes in all colorful dresses. But we only think is we have to cover our body. So naturally, when gold and silver are there in the family, and especially you can imagine in a Vaishya community and Kamma community and prosperous communities, of course, Brahmins are very, very poor. They don't have that much as these communities have. Then what they do is, the jewels are kept and jewels are distributed among the daughters. And please remember, then the friction starts. The daughter-in-law says, "Sir, I have, I have, I have used my sweat and toil, looked after my in-laws, and see my parents-in-law how selfish they are. They are giving all the gold and silver to the daughters, and I have also got daughters. My daughters also have to get married tomorrow. At least they must give something to me." But in some families, what they do is they distribute it among to the daughters-in-law also. If they don't distribute to the daughters-in-law, then the trouble for the parents start. That is, they will not be listening to their parents-in-law. They say, "Anta kuturke ichava, nakim ichava, musti ichava naku, then I'm not going to obey you." So what happens is mostly the disputes start, especially regarding gold and silver, because ladies may not like their husbands, but as far as gold and silver are concerned, they don't part with that.
I'm audible or anything disturbance is coming up? Madam, unmute చేయండి ఒకసారి అందరిని ఒకసారి. Any disturbances?
No, sir.
No disturbance. Okay. Already I got it.
Very much audible, sir.
All right.
Thank you.
Carry on, sir.
Yeah. So the near.
Madam.
The real friction starts in the family regarding gold and silver. Gold and silver is one thing which creates enemies, and there is no love lost between the daughters and the daughters-in-law. Because the daughters, please remember, sometimes our families are also to be blamed for that. Why? Because the entire thing they give to the daughters, as far as the daughters-in-law is concerned, they don't give anything. So that better to have an equal treatment for daughters as well as the daughter-in-law to avoid future disputes. Whether it takes place or not, it's a different matter, sir. As far as the one of the ways of keeping the what is called property within one's own family is getting married. Suppose you have got a son, you get your son married to your sister's daughter. Our sister has got a son. Ichi puchkodam antaru chudandi. Your sister has got a son, you give it to your daughter. Like that, what happens is you give your property because you get your daughter married to the son of your sister, then the daughter of your sister gets married to your son. What happens? It goes from this end and again comes back to the same family. And that is the reason why the Kamma community, of course, I'm not meaning anything if anyone belongs to the Kamma or the Vaishya community, please. I'm very, very secular. I believe in Samajika Nyayam. So the question is, here, as far as most of the fictions which arise is, and here in Kammas you have seen, especially the honor killing which they practice, that is a Kamma girl should not marry a person from other community. And because what happens is property goes outside. That is the reason they say wheels within wheels, the property remains within one's own family. And one of the ways of allowing it to remain in the same family is to execute a family settlement. And family settlement only requires one person duty, stamp duty, which is leviable. It's the cheapest possible. Then again, I like to distinguish here. There is one thing called, especially I think if I'm correct, it is Vaishyas and Kammas. When the girl gets married, the daughter gets married, they give some property or some jewels as Pasupu Kunkuma, as they call it. Pasupu Kunkuma is they respect the girl to whom they have given birth, and the girl is provided something so that the husband may not grumble tomorrow, and it is normally called the Sri Dana. Sri Dana means Sri means lady, Dana means gift. So whatever gift has been given at the time of marriage or during a marriage settlement, that is called the Pasupu Kunkuma. And Pasupu Kunkuma doesn't require stamping and doesn't require registration. But the government has woken up saying that even what is given as Tridhana also has to be registered and proper stamp duty has to be paid. Government does not leave you anywhere, sir. It is something like what is called, it is something like a devil which is on your neck. At any time it may pounce on you and even kill you. So the question is, government intervenes almost wherever there are loopholes, the government tries to plug it. So Sridhana, and please remember, a normal defense which is taken by these ladies when they come to court is, this property does not belong to my husband, but it belongs to me because I brought enormous wealth from my family, and out of that money, the property has been purchased. And please remember one thing is that when you purchase a property in the name of your wife, be very, very careful. So long as you are happy, so long you have got in cordial terms, so long as there is no friction in your family between the husband and the wife, it is fine. But once the frictions start, differences start, then what happens is the wife tries to assert her title or ownership over the property. There is one thing called an act called Benami Transfers Prohibition Act, where it says whomsoever's name is mentioned as the owner of the property is deemed to be the owner of the property. Again, there is one more section in the Hindu Succession Act called Section 14, Women's Property. Please remember, women are no longer inferior to men today. They are given a lot of powers, lot of gifts also. What you call it is the as far as the women's property is concerned. No, after the Hindu Succession Act was passed in 1955, a woman has got absolute rights over the property, and if her name is shown as the owner, she continues to be the owner of the property, and you cannot question it. But even if you want to question it, you will have to come under the Benami Properties Transfer of Prohibition Act, whereby you will have to show my wife was only a lady of straw. She did not bring anything from her family. She had no dana, much less Sri Dana. And entire property was purchased by me. I raised loans, but I placed it in the name of my wife. I purchased the property, and my salary was being deducted towards the EMIs. So the burden is on the husband to prove all those things. Now, are you not finding it among cricketers who are getting separated also? So the latest is Hardik Pandya and his wife Natasha Stankovic or something. So question is, how richer the person, richer the expense you have to pay. And in order to get a divorce, you will have to pay a heavy sum towards our alimony and then get rid of it. So be very careful, sir. Family settlements are not in vogue today. It is prevalent only among 2 or 3 communities. There are the Vaishyas, Kammas, and the Kapus also. Kapus who are very, very prosperous in Andhra area. And as far as Brahmins are concerned, they have no property at all. Where is the question of family settlement? So we live for day, at least as a Brahmin is concerned, he lives only for that day. And especially people who belong to the Purohitam, that is people who perform various functions, they are men of straw. They don't have that much money as the other communities have, because if you see the Shastras also, they say Brahmin is born, the quality of a Brahmin is only to preach and beg on the streets and ask for Bhavati Bhikshan Dehi. He shall not earn anything, he shall not work anything, but dedicate himself to God. That is our duty that has been enshrined in the Shastras. Of course, let us not dilate about it, because it is something like making aspersions on some community. Then we go to the next document called the partnership deed. Partnership deed, again, I'm repeating it, sir, because often questions are being asked, what is the liability of a individual partner? I've answered that question also in the chat box. As far as a partnership is concerned, the liability of a partner is joint and several. Every partner is the agent of the other. Every partner is the manager of the other. And for the assets and liabilities, all the partners are equally entitled. And a firm has no independent existence sans the partners. Death of a partner ipso facto puts an end to the partnership deed unless it is dissolved. And a minor cannot be admitted as a partner of the firm except to the profits of the business, so on and so forth. So a partnership deed, then how a partnership is defined, sir? Again, I repeat it for the benefit of those who are asking it in the chat box frequently. A partnership means it's an agglomerate of it's an agglomerate or combination of 2 or more persons who come together, pool up the resources proportionately, build up a foundation called the capital, and on which the edifice or the structure called the business rests, and with the ultimate object of distributing the profits amongst themselves is called a partnership. And collectively, they are called a firm, and individually, they are called partners. This is how the proper definition or objective definition of a partnership firm is. But if you see your Partnership Act, it defines the partnership as where 2 persons come together in order to share the profits of a business. It is called a partnership. It is not the correct definition. So the definition which I've given you now is the objective definition and the proper definition as far as the partnership firm is concerned. Then how a partnership deed has to be formulated. Before we draft a partnership deed, two things are important, sir. In the Partnership Act, Section 57 to 59, and Section 69 are very important. Section 57 says that every firm, because a partnership does not have an independent existence, it should comprise of two or more persons. And if a firm which comes into existence will have to be duly registered under the Indian Partnership Act, and it must get what is called a registration certificate or RC, or acknowledgement from the registrar of firms, called acknowledgement of firms. So from Section 57 to 59, a firm has to be compulsory registered. Then one more disastrous section is there, Section 69. 69 says no suit can be filed against a third party unless the firm is registered and the person suing or bringing an action is shown as a partner in the extract of partnership. Then only a suit is maintainable. So what are the two things required, sir? One is the firm has to be registered. Second one is the firm has to be registered, and the person suing or the person bringing an action against a third party should be shown as a partner in the deed of partnership. And one more misnomer you have to take it out of your mind is a partnership deed is not registered, please. What is registered is only the firm. And what certificate is given to you is a registration certificate, or a certificate as called as acknowledgement of firms, that the firm has been registered with a particular number with the seal and signature of the registrar of firms. And the another thing is extract, that is under Section 69. It is called a specimen A form under Section 69(2), saying that these are the following partners as far as the partnership partners are concerned. The day when the firm has come into existence, what is the name of the firm, what is the duration of the firm, and then what are the respective contributions made by each partner, and then the assets and liabilities, what is the liabilities ratio which has to be shown. This will be shown in the extract of partnership, and it is called specimen A form, issued by the registrar of firms under the Indian Partnership Act. Then we come to the documentation part of it. In a partnership deed, what are the basic requirements, sir? First is there must be two or more parties. That's the first one. Second one is there must be a capital investment that is made, not equally but proportionately. Third is there must be an edifice called a capital. Fourth one is the assets and liabilities of the firm also has to be clearly mentioned. Then the profit sharing ratio of the partners have to be clearly mentioned. And also, what is the name of the firm? What is the duration of the firm? What is the objects of the firm? For what purpose it has been formed? And the question is how they will conduct their business. Then who is designated as a working partner? What are his responsibilities? Who is designated as the what is called the main partner? Who is designated as a dormant partner or a sleeping partner? All this formality, all these clauses will have to be included in the partnership deed. And what is the investment which is made towards the capital also has to be clearly mentioned. And the proportionate share amounts contributed by the partners should be clearly mentioned. And then the question is how much each partner is entitled, 30%, 40%, 20%, 10%, so on and so forth. What is the accounting year as far as the firm is concerned? When will the balance sheet be prepared, and when it will be laid before the partners for the discussion? And then what are the assets and liabilities? And then the question is what are the incoming contracts which the firm has to follow or implement? Then next one is what you call it as what is the duration of the firm, and then what are the objects of the firm, what are the ancillary objects which the firm can carry on, then who are the persons entitled to operate and open the bank account, who are the persons who are authorized and empowered to apply for credit facilities from financial institutions, whether the property, then another thing is who is entitled to pledge or hypothecate or mortgage the assets of the firm for obtaining as a collateral security for obtaining a loan, and whether future properties have to be purchased, if it is to be purchased, in whose name it has to be purchased, so on and so forth. All these conditions you'll have to mention in a partnership deed. And also, it has to be signed by every partner, first partner, second partner, third partner, fourth partner, and witnessed by 2 witnesses. This is how a partnership deed has to be executed. Then one more document which you can visualize is what is called Memorandum of Understanding. Please remember, Memorandum of Understanding is not our Indian word. It has been incorporated after the IT had come into effect. And now, అంటే మనం ఇద్దరు ఏం ఒప్పుకున్నాము ఆ ఒప్పుకున్న ఇది వృత్తాంతం ఏమి that we write it as a memorandum of understanding, or what is popularly called MOU. MOU, you say what are the terms you have agreed upon, whatever, for what purpose you have come together, why this MOU has been executed, how much each person has contributed, what will be his profit sharing ratio, what will be his liability in case the liabilities are foisted on them, how a partner should conduct himself, so on and so forth. That is what is called MOU. No much significance need not be given to it, but it is signed by all the parties who are parties to it. Then please remember, government does not leave you there also. Government says, if you all agree, where am I? So you'll have to also get it registered because it's compulsory registrable under 17(1)(b). Then we come to another hybrid document called AGPA, Agreement of Sale, and GPA, or General Power of Attorney. Here, as far as agreement of sale come GPA is concerned, it is compulsory registrable. The question is, the seller and this purchaser, they enter into various terms, same thing like a sale deed. But the reverse of it, it is registered, and the whatever, and you have to pay the entire stamp duty. As far as the AGPA is concerned, the entire consideration has to be paid, and then the document is duly registered as an AGPA. Yesterday I also discussed about the Suraj Labs case. There is Suraj Labs Limited versus the Delhi Development Authority, where the Supreme Court has put its hand on that and said an AGPA cannot be specifically enforced to a court of law unless the entire stamp duty is paid and the entire consideration is paid. If it is not done, it's a waste paper. It has to be thrown in the waste paper basket. That's what the Supreme Court said. But you can definitely distinguish it by saying, sir, this ruling does not apply as far as my case is concerned because I paid the entire consideration. I paid the entire stamp duty. You can look into the document and then find out whether the stamp consideration has been paid and whether there has been a payment of stamp duty, registration charges, so on and so forth, which is endorsed by the sub-registrar at the time of registration. If that is done, please remember that agreement can definitely be enforced in a court of law. But after the Suraj Labs case came in 2004 or 2005, it says if you don't pay the stamp duty, if you don't pay the entire sale consideration, it cannot be construed as an agreement of sale. But the question is, it is not enforceable at all. Then why, sir, it is called a hybrid document, sir? GPA is also given in the same document. They say the purchaser also is the GPA holder. The purchaser is entitled to look for alternate purchasers. He must look to the prospective purchasers. He looks for the prospective purchasers. He has got the power to execute and register agreements, sale deeds, so on and so forth. He has got the power to even hypothecate the properties for getting loan. He is entitled to proceed with the necessary authorities, obtain clearances and permits. All the powers are given to him as far as the purchaser is concerned. Please bear one thing in mind, that word purchaser means and includes nominees, assignees, transferees in interest, so on and so forth. That means the GPA or AGPA holder, as you call it, is entitled to sell it on his own name in favor of a third party and convey a good title. That is the consequences of an AGPA agreement. Then the question arises, sir, should not a sale deed be executed? No, you can always get it done. When you get the sale deed executed and registered, the stamp duty which you have already paid towards the entire sale consideration will not be collected again, but a formal sale deed is properly executed and registered, and then a proper number is given to it. That is what is called an AGPA. Then nowadays, old structures are being demolished. We are going into for flats and residential and non-residential complexes or commercial complexes, as you call it. It is called development agreement come GPA. Development agreement come GPA means where there is a contract between the owner and the developer. The developer who has got the skill and experience in the building activity, and then he has got the labor also with him. He undertakes to finance the project, and also the various clauses are included. Then in that he says the owner is entitled, the developer after construction is entitled for 60% of his share, the constructed property, and 40% shall belong to the owner. And the respective allotments which are going to be made also will be earmarked in the same development agreement. That please remember, no developer parts with the ground floor, because ground floor normally make commercial mudgis or shops. First, from the first floor it starts. Not that your owner will get it in the same floor. He gets one thing in 101, he gets one in 201, he gets in 301, he gets in 401, so on and so forth. Suppose 20 flats are sought to be constructed. Out of the 20 flats, 14 flats go to the developer and 6 flats come to the owner. The reason being, the entire finance for the property, for the construction, obtaining permits, obtaining clearances, going and liaising with the various authorities, and also raising bank loan, and also constructing the property, using the material, the labor force, everything is done by the financier or the developer. What all you do is sit happily in the armchair and you get your 40%. But the question is, there is a practice also in the development agreement. What they do is, when you hand over possession of the property for the purpose of construction, you hand over all the documents, number one, and also you give an authority to the power of attorney to do everything on your behalf. When he does it, he is entitled for 60%, that is the builder, and you are entitled for 40%. And a plan also is drawn up as to what are the flats allotted to the builder, what are the flats allotted to the owner. And please remember, earlier the development agreement come GPA was not registrable, but now the government has woken up by saying that a development agreement come GPA also is compulsorily registrable. So a development agreement come GPA is compulsorily registrable. Suppose there is a breach or violation on the part of the builder not commencing constructions or not completing the constructions within the stipulated date, instead of going to a civil court, you can go to a consumer court, and for deficiency of service, you can definitely make the builder liable and responsible for it. And normally there's a clause also mentioned, in case the builder does not commence or complete the constructions, he will be liable to pay liquidated damages of so much amount to the owners. And please remember, sometimes the situation so arises that the GPA holder, that is the developer, as well as the owners, come together and execute the documents in favor of the prospective purchasers. Then one more hybrid document is there, sir, called Agreement of Sale and Purchase. That is, yesterday when I gave you the examples, I said when it's a money lending transaction, the amount which has been lent as hand loan has to be repaid within 3 months period. Here, what the person who goes to debtor does is, he executes an agreement of sale, agreement of sale and agreement of purchase and sale is, suppose the amount is repaid within a period of 3 years, the sale deed, which or the agreement of sale which is executed, becomes null and void, and the seller becomes, the person in whose favor it is executed becomes liable to reconvey the property back to the purchaser. So that is gone now, sir. But now it is not. Then in the next class we will be discussing about the mortgage deeds, because mortgage deeds I will have to discuss about 6 mortgage deeds. There is simple mortgage, mortgage by conditional sale, English mortgage, usufructory mortgage, anomalous mortgage, and mortgage by deposit of title deeds, as embodied in section 58 of the transfer of property. Thank you very much. The time for interaction starts. Yes.
Sir, good evening, sir.
Good evening. Just a minute, sir.
Sure.
Please go ahead, sir. Yes.
Yes, sir.
Yes.
So you mentioned about the Muslim personal law.
Yes.
And about the Hiba Nama.
Yeah.
So, and you also mentioned, sir, that registration is not required.
Yes.
And it looks like it mostly goes around verbally.
Yes.
So how is it enforceable?
So what they do is, once it goes on verbally, they reduce it in the form of a memorandum saying that this has been gifted, possession has been delivered, actual possession, physical possession, vehicle possession, constructive possession, or symbolic possession, and the tenants who are in possession of the property, let us say, they have been assigned to the donee, and in future they'll be directed to pay the rents to the donee who has been the beneficiary as far as the gift is concerned. But one important thing in a hiba, as far as Muslims are concerned, delivery of possession is must, and delivery of possession completes a gift as far as a Muslim is concerned, but it doesn't require stamping, it doesn't require registration.
And so this memorandum has to be signed by both the parties.
Signed by the donor as well as the donee, because the offer of gift and acceptance of gift, and attested by 2 witnesses.
Yes, okay.
But delivery of possession is compulsory.
And sir, can you please also touch upon you said 1 by 3rd.
Sir, good evening, sir.
1 minute, sir. Let Mr. Prasad finish it.
Yes, sir.
Yes.
Thank you, sir. So you also mentioned about the share.
Yes.
Is it only 1 by 3rd can be?
A Muslim can gift only to the extent of 1/3, sir, not above that. Other shares go by inheritance. If you want the law of inheritance, then in that case, the widows, if there are more than one, suppose 4 widows are there, they take equally 1/4 in case they don't have children. But if they have children, they take jointly 1/8. That has to be distributed among those 4 people, and males get two shares and females get 1 share.
Okay, sir. Thank you.
Mr. K.Santhanam, please go ahead.
Sir, can I just have this about the Waqf board, sir? They can acquire any property, sir?
Waqf cannot acquire any property, sir. The question is, suppose the property shown as a Waqf property, then it cannot be alienated, it cannot be sold, or it cannot be encumbered without the permission of the Waqf board. And even if a sale deed has to be executed, it has to be executed by the Waqf board alone, not by any other person.
But do they have the right to acquire any property, sir?
Sir, as far as my knowledge goes, Waqf has no right. The only thing is it's only dedication, sir. Something in Hindus we call it as endowment. In Muslims they call it as Waqf. That is a charitable endowment. As far as a Muslim is concerned, it's called a Waqf.
Okay.
Yeah, and it's called Awqaf ka Jaidad. Awqaf means Waqf board.
But several these Mutawallis have sold the lands and created a problem.
Thank you.
Lot of mess is there as far as Waqf properties are concerned, sir. The question is, here what happens is, whoever gets the opportunity does it. Are we not selling temple properties or endowment properties? Hindus. And university, if you take, for example, you take University, Usmania University had its properties till Apsiguda, or even beyond that. Even Nacharam area belonged to the university. But today you have palatial buildings there.
Yes, sir. Every time students do a lot of demonstrations, but nobody cares.
Nothing will happen,
estate
sir.
officer sells survey, goes on with
Sir,
the connivance of Vice Chancellor.
Sir, what happened was, when Navneet Rao was the Vice Chancellor of Usmania University, he tried his best.
Very strict.
He tried to fence,
Very strict.
tried to construct compound wall showing the Usmania property. But everything is over by that time. Today you have that, what you call, big hotels are there, SKN and all these things. That is what called, big hotels have come. They are all Usmania properties only.
So Navneet Rao was a great Vice Chancellor. We proudly say that we are graduates from Navneet Rao time.
Yes,
That
sir.
is, no cheating, no copying was allowed.
I was there from Jagannath Reddy's time, sir. That is, I still remember Jagannath. I never knew that is Jagannath Reddy. Then what happened in a particular seminar? I said, "Evado Jagannath Reddy anta, what Supreme Court judge, what Vice Chancellor ayidanta, evado Turkodi తీసుకొచ్చి పెట్టాడు." And the question is, Professor Imam was there. He had a hatred towards Hindus. Then I said, "What sort of person he has brought?" Then you know who is Jagannath Reddy? I said, "I am Mr. Jagannath, sir. Glad to meet you."
Yes, sir.
Sir, when the property, agreement of sale is done in the name of a wife, husband transfers the entire consideration amount from his account to the
Yes.
seller,
No.
can he claim any litigation later? Can he do any
Only thing is
litigation?
he must come under the Benami Properties Transfer of Prohibition Act. That is where he has in the section 3, he has to show the source of consideration. He has to show how consideration was paid, how he had raised loans, what was his earning capacity, what was the earning capacity of his wife, so on and so forth. It's a very big litigation, sir. That's why if you are clever enough, don't keep any property in the name of your wife.
One incident occurred when I was Inspector Begum Bazaar and DSP retired. Mr. Khan was a famous DSP in task force.
AK Khan.
AK Khan.
Yes,
he came to me against his wife that she is troubling him regarding the property. When I called his wife, I said, sir, madam, property to aapke husband ka tana paise. She smiled and said, might be, but it's in my name now. That's
a problem of Benami. It's a Bemani, not the Benami, sir. Now it's called Bemani properties.
Yes.
Dishonest properties.
Let Muralidhar garu 1 second. Venkat Sachinayan garu, please go ahead. Sir, Venkat Sachinayan. Please go ahead, sir.
They don't do it, sir. But if you see the law of registration, even an MOU is registrable if it concerns immovable property. Yeah.
Yes,
but they don't do it. Normally, they don't do it. You know, in Hindi they say, "Miya bibi razi hai to kya karega qazi." If both of them agree, they doesn't come to court. Please remember, as advocates, we are losers.
Sir, but in the case, actually, on the basis of any computer court.
See, MOU, if you see the conveyancing is nowhere defined or nowhere mentioned. But this transaction which has come from the United States of America, especially after the IT Act has come, that is information technology, whereby these MOUs is understanding between both of them, sir.
Okay. Yes. But they MOU, they not find any issues like that.
Sir, these MOUs are normally relied upon by companies in the IT sector, sir. Because between one company and another company, normally it is not found, sir. Very rare to find MOUs. Even an agreement of sale is made in the form of an MOU to cheat the government. That's why the government has said even an MOU has to be registered. Yes.
Mr. 1 second, one by one, Mr. Prasad garu already put it. Murthy garu, Sriram Murthy garu.
Sir, yes, Mr.
Sir, generally, the agreement of sale has been executed upon 100 rupees stamp paper since long time.
Sir, now it's not 100, sir. It's now 200, sir.
I want to know that what is the legal sanctity of that agreement which has been executed on 100 rupees stamp paper, whether it is compulsory execute registered document or not.
It has to be compulsorily registered under 17(1)(b) after the amendment of the Registration Act in 2001, effective from 1/7/2001. Now it is not 100 rupees, sir. Now it's 200 rupees from 2015.
2015?
Yes, 15, 1/5.
1/5 is 200 rupees.
200 rupees, not 100.
So any dispute with regarding that aspect, what is the legal sanctity?
You can definitely take a plea if you are the defendant to say it is not on a proper stamp paper, it has not been properly executed, it has not been registered as required under 17(1)(b), so it cannot be looked into for a primary purpose.
Only collateral.
Yes, sir. That's all.
Oh.
What is your please go ahead.
Sir, would you please elaborate verbatim document or verbatim copy once again?
Pardon?
Verbatim copy.
Verbatim means whatever is written in the original, the same thing will be copied in the counterpart, and one will be given to the first person, second one will be given to the second person, third will be given to the third person, and it is taken out of the same computer, the same print, same clauses, everything. There is no change at all. It is verbatim copying of the original document. That's why we say verbatim copying. That's why it is called counterpart, not duplicate, sir. so that everyone will have
Registration.
all the 4 will be registered.
The registration is over nearly 5 weeks back.
Yeah.
Can we get it the verbatim copy now?
No, sir. It has to be done simultaneously along with that. You can get a certified copy, no problem regarding that. But as far as if you want a counterpart copy, then the question is when you submit the original document for registration, along with that, the other verbatim copies also will have to be given and registered as counterparts.
Okay, sir. Understood. Thank you.
Prasad Rao garu, please go ahead.
Sir, in other extension to the earlier question, in other words, is it that 4 originals have to be prepared?
Exactly. So you're right.
Okay.
And when you submit 4 originals, 4 extra copies also has to be given, because what they do is the book they just paste it. They are not writing it nowadays.
Okay, sir. And second question, sir. So we were also discussing about the partition within the family, family settlement.
Yeah.
During that course of discussion, it was mentioned that especially for between the daughter-in-law, there will be some disputes while partition of the
mobile property.
Jewelry and all.
Yeah, gold and
jewelry.
Yeah,
gold and jewelry. At the same time, we're also talking about Pasupu Kunkuma and Sridhar.
Pasupu Kunkuma at the time of marriage, sir.
Okay, that's only at the time of marriage.
Marriage, not afterwards, sir. But I'll tell you one more instance, sir. What happened was when the Land Ceiling Act had come in 1971, you can't hold more than a particular area, isn't it, sir? Unit. Then what they did was artificial divorces had come into play, marriage settlement, artificial matrimonial cases had come into play, and the stamp duty at that time was only 2 rupees 50 paisa. What they used to do is this 2 rupees 50 paisa stamp paper used to be sold for 5,000, 10,000 and all. As far as they used to give it as an antecedent document by saying it has occurred long time back, and because both of them are separated from each other, it is given towards marriage settlement. So this has happened everywhere, not only in Telangana but in Andhra area also, sir.
Okay, sir.
Yeah.
And sir, so since you said Sridhana
is what is given by the parents to the girl at the time of marriage towards a marriage settlement. It is called Sridhana. That is Dana belonging to the Sri. That is the daughter of the family.
Yes, sir. So can anybody argue that since the daughter has already been given Pasupu Kunkuma,
no, sir. Now
she will not be allowed for partition in the
No, sir. The
property,
question is not partition. You can say not for a share. I just put it that way. After 29A has been introduced, there they say girl child born as an equal right along with the brothers as far as ancestral property is also concerned. But as far as self-acquired property is concerned, a daughter also comes under class 1 here under section 8 of the Hindu Succession Act. So Sridhana is immaterial for this.
Okay. In other words, in addition to Sridhana, a girl child is also
entitled for a share. Yes. Even if she is not interested, her husband will pester her for that.
Yeah, sure.
Because most of them who come to me are the sons-in-law and not the daughter.
Yes, sir.
Satyavati garu. Madam Advocate Satyavati garu, please go ahead.
Sir, good evening.
Good evening, madam. Good evening, madam.
Sir, good evening, sir.
Good evening, madam.
Sir, ఇప్పుడు మనం sir చెప్పండి.
Yes,
madam.
madam.
My voice break. Would you please come in the network?
ఓకే సార్. సార్ ఇప్పుడు మనకి ఇంతకు ముందు సార్ చెప్పారు కదా 4 డాక్యుమెంట్స్ ఒరిజినల్ డాక్యుమెంట్స్ 4 మెంబర్స్ కి మనం సేమ్ అంటే జిరాక్స్ కాపీ లాగా రిజిస్ట్రేషన్ చేస్తారు.
Don't misunderstand that way. It's not Xerox copies. Same document registered 4 times, but having the same matter. That is called counterpart, not duplicate also.
Okay, not duplicate.
Not duplicate, madam. It's as good as an original. As good as original, but extra stamp duty will be collected. Extra registration charges will be collected.
Okay. Thank you, sir.
Right.
Mohin Sheikh.
అర్థమైంది.
Right, thank you.
Sir, good evening, sir.
Good evening,
Mohin from Vijayawada.
Yes, sir.
So actually, I have a couple of doubts with regards to Mohammedan land, sir. So the first question is with regards to a title holder. He's a household title holder can transfer his property to his son without the consent of the other family members.
See, one thing is this: for the test for that is how that person has acquired that property, whether he has acquired it with his own money, or whether he has acquired it from his ancestors, or whether it is construed as a matruka property, which is heritable. If it's a matruka property, all of them get a share. But as far as self-acquired property is concerned, he can do whatever he wants with that property.
Okay, sir. And so the other one is with regards to same Mohammedan law itself. Yeah. So if it's a gift deed has been executed on behalf of within the family member, so the rest of family member they didn't get this information as such. So the limitation applies as 12 years, sir.
No, from the date of knowledge, whenever they get knowledge of that document.
Okay, sir.
Not on the date.
Okay, sir. And okay. Oh, thank you, sir. And one other thing is actually when joint title is there with the Mohammedan law, joint deed is there with Mohammedan persons. So if it is, they want to one person would like to acquire the other person's share. So is this any deed that they have?
Sir, yeah, that is what is called in Muslims only it prevails. There's right of preemption. One of the shareholders, one of the joint owners has got a right of acquiring the share of the other, and he should be given a preferential right, and he should be offered the property as a first choice and then only sold to an outsider. That is called right of preemption. It's only prevalent in Muslims, not other way.
Okay, sir. Yeah. Thank you, sir.
Vasantrao garu.
Good evening, sir.
Good evening.
Sir, please speak loud, sir.
Good evening, sir.
Good evening.
One, I have doubt in partition, sir.
Yeah.
After death of the father, fathers are distributed their properties by settlement of family settlement.
Yes.
And they took over the position, their respective shares and contributed the same.
Right.
20 years back.
Right.
And what is the remain is because the petition was not taken place.
Pardon?
Your voice is cracking, sir. Please come in the network so that we can understand.
The revenue records that partition that family settlement was it was not reflected.
Right.
And one brother is now disputing the partition.
Right.
Though he is cultivating his part of land, he is not coming forward to exclude the partition deed or anything.
Right.
Then we have to file a declaration suit.
Yeah, you have to file a declaration suit, assert your rights and say, I've got rights, but this has been disputed by the opposite side. I want a declaration that I am the owner of this particular site.
Yeah, making other persons as party
if you are not in possession, you must also ask for possession, because without asking for possession, you can't ask for declaration, sir.
Yes, sir. Already position was the rest of the already respective.
No, if you are already in possession, the relief you should ask is confirmation of possession.
That's enough, sir?
More than enough, and declaration also.
Only declaration, only enough, sir.
Declaration that you are the owner, and also for confirmation of possession, since you are already in possession of the property.
Confirmation of possession.
Yeah, sir.
Okay.
Any more questions?
Sir, namaste.
Namaste.
Sir?
Sir, Nagachandran from Hyderabad, sir.
Yes, please go ahead.
Sir, ఇద్దరు భార్యలు ఉంటే సక్సెషన్ యాక్ట్ ప్రకారంగా ఇద్దరు భార్యల పిల్లలకు
హిందూస్ ఆర్ ముస్లిమ్స్
ప్రాపర్టీ మీద ఏం రైట్స్ సార్?
సార్, ప్రాపర్టీ మీద సెకండ్ వైఫ్ marriage is not recognized, sir, because first wife alone, so long as the marriage is subsisting, the first wife gets the first right. But the question is, nowadays Supreme Court also has interpreted, saying that though monogamy is permissible in Hindus, since there are two wives, it is advisable that both the wives share equally.
Second
wife's marriage is not a marriage at all once the first marriage is prevailing. పిల్లలకు వస్తుంది. పిల్లలకు, even if they get children, the children are entitled for a share, not the mother.
Not mother. Children are the eligible for rights, sir.
Yes, sir. But the Supreme Court has interpreted saying that even the second wife also is entitled.
Yeah, they are
Only for the children, not for the wife.
Supreme Court guidelines.
Yeah, that is definitely the Supreme Court dicta is there. Even the second wife is entitled.
Okay, okay.
Yeah.
Thank you, sir.
Right.
Any more questions? Can we wind up today? Citation, please. MVS Sharma, sir. Citation అడుగుతారు.
దేనికి?
ఇప్పుడు మీరు చెప్పింది Supreme Court.
Supreme Court, sir, it was not reported, sir. It was only on paper which I went through and I'm repeating it to you, sir. There is no citation for that.
All right. Any more questions, sir?
Moin
Sheikh, your question is over?
Yes, sir. Yes, sir. It's over, sir.
Please hand down.
One question.
Yes, sir. I'll do that.
Prasad Garu.
Yes, sir. Sir, during the partition, is there any set of guidelines sort of thing that who will
hand
get?
down if you have no questions.
There is no guidelines, sir. Actually, it should be property.
For example, this elder son will get this
No,
particular
if
portion.
in the partition deed, suppose the elder son gets a larger share. I just take an hypothetical example. Then the stamp duty has to be paid on the larger share, and people who have got lesser share, they have to be compensated out of the larger share. That is the other 2, 3, 4. They have to be given money compensation, sir.
And the choice of the properties, suppose I want east, I want west, like that.
No question of choice, sir. It is the old man who has to do it.
Okay, as per the owner.
మీరు అన్నట్టు 3-side road, 4-side road అంతా లేదండి. మన అట్లీస్ట్ ఆ ప్రాపర్టీ వస్తుంది మనం సుఖపడాలి. అదని సపోజ్ ఓల్డ్ మ్యాన్ సేస్ ఐఎమ్ గివింగ్ ఎవ్రీథింగ్ టు చారిటీ.
అయిపోయింది. ఫినిష్. All right, Mr. Koteshwar garu.
Or the best way is to go for sticks or lot.
Anurag garu cheppandi.
Yeah, best way is to go for sticks or lot.
Madam, I was just waiting for you. I was just waiting for you. Ask one question. Suppose the drawee loses the check. What are the consequences?
Yes.
But here, I'd like to clarify regarding that. The question is, the countermanding of the check can be done immediately, or inform the bank that I've lost the check. This is the check number and this is the date, and this person has given a check to me. I've lost it. Please countermand the check and stop payment.
Okay. Thank you, sir.
Yeah.
Mr. Koteshwar.
Sir, if immediate link document is missed, how to go about it, sir?
Take a certified copy.
Certified copy.
Or even a Xerox would do. Link document, no one asks you. But when you want to get a document when you apply for a housing loan and all, they ask you to show the original link document, sir. Or take a certified copy of it. There's no loss for it.
Yeah. At the time of sale, I think sale, we need to give all the link documents.
You have to ask for that. No, vendor will not give you just without asking. You have to take all the documents. That's why they say there is a document called KV Temptar, buyer beware. Like in they say as far as consumer is concerned, Jago Garak, same thing. That's how we'll wind up. Sir, as far as any questions on law is concerned or any legal problems, you can contact us. We are here to clarify, and we are to the best of our ability, we'll answer your problems, sir. Thank you.
Any questions you have regarding anything in legal aspects or filings or anything, please do feel free to call us. We'll help you out in that. So you have my number, I hope so. You can. Sir, Sai Prasad Garu is asking some questions. Sir, when the documents to be sent to the FSL regarding the specimen signatures, before or after trial, during the cross-examination?
See, here, as far as FSL is concerned, when the document is filed in the court, it is your duty to immediately file a petition under Section 45 of the Evidence. I'm talking about the old Evidence Act. Ask the court to appoint to send it to the expert for examination, and that should be before the document is marked in evidence at the time of cross-examination or otherwise, because Section 35 and 36 of the Stamp Act says if you don't raise this objection at the earlier stage, later on you cannot question the genuineness of that document. That should be done before it is exhibited, sir.
Okay, Sai. Any more questions or can we wind up for today?
Kalyani garu, 1 second.
Please, ma'am. Please go. Chepan, madam, Bakraju.
I missed to understand the difference between relinquishment deed and release deed.
See, madam, relinquishment and release both are synonymous. Relinquishment is I have got a definite 1/4 share. I am giving up that 1/4 share in favor of another person who exercises the right of preemption. Preemption means he has got the first right to purchase my share for whatever value it may be. As far as release is concerned, it is almost the same. I give up my share and say I don't want to claim anything. That is called release deed.
For example, I can give you in this way, madam. Madam, ఇప్పుడు ఇద్దరు వ్యక్తులు ప్రాపర్టీ తీసుకున్నారు. అంటే తండ్రి కొడుకులు కలిపి ప్రాపర్టీ కొనుక్కుంటున్నారు. Both the titles. They hold both the titles. ఇప్పుడు కొడుకు పేరు మీద ట్రాన్స్ఫర్ చేయాలంటే రిలీజ్ డీడ్ చేస్తే ఏమవుతుందంటే కొంచెం ఎక్కువ అవుతుంది. 3% అవుతున్నది. 3.5% ఇస్ రిజిస్ట్రేషన్ ఛార్జెస్. అప్పుడు ఏమవుతుందంటే రిలీజ్ డేట్ మూలంగా మీకు ఇన్వోకబుల్ అవ్వదు అండ్ ఈ విల్ రిలీజ్ అకార్డింగ్ టు హిస్ విష్. అంటే నాకు ఎటువంటి హక్కులు లేవు అని చెప్పి రిలీజ్ చేయడానికి దట్ ఈస్ ఎ పాసిబిలిటీ వాట్ వి హావ్.
I just try to amplify this. Suppose the property is purchased by two people. I just put it in a better way, 50-50%. So I'm saying I'm not going to claim my 50%. This 50%, let the other fellow also take it. That is what is called releasing my 50% share.
Perfect.
Or the wife says, I've got a lot of love for my husband. Let my husband take that other 50% share.
Same way.
Madam, you are a female. I don't want to go further because of the Benami Transfer Prohibition Act. Purchasing property in the name of a wife is very, very dangerous now.
Sorry,
if you have read the paper today, the case of Hardik Pandya and his wife have separated from each other. But the question is, exactly.
Chakravarti Sriramurthy garu cheppandi sir. You have a question for you. Sriram Chandramurthy garu.
Sir, for filing divorce petition, whether we have to wait for 1 year, is there any exemption?
1 year from the date of marriage, no divorce petition can be filed. But under Section 14 of the Hindu Marriage Act, you can always ask for dispensing with that period of 1 year. If you show extraneous considerations and say matter is very, very urgent. That's what the Supreme Court also has interpreted, that the cooling off period is not there.
So, any judgments are with regard to
that? Give you that citation.
There is a citation, sir.
I'll give you
citation. This cooling waiver period has been waived off. There's a citation for it. We'll send you across.
That Chhattisgarh, the earlier judgment is Chhattisgarh statement and Supreme Court judgment also has come. The cooling off period does not arise.
We'll send you that citation also.
And even that 6 months waiting also has been dispensed with now.
Yes, sir. That's also. Please, both judgments I require.
So mutual consent, there is a waiving of also.
Yes.
And we have a citation, the Supreme Court citation is also available. We'll send it across in the group, sir. You are there in the group, sir?
Sir?
You are there in the group?
Yes, I am in the group, sir.
All right, I'll send it in the group, sir.
Thank you.
Thank you. Any more questions?
Samardeep Singh versus Harvinder.
Evaro maatadutunnaru.
Priya garu,
please. Madam,
sir,
page address చేయండి so that we can address in the proper way. చెప్పండి ప్రియ గారు.
నేనే I'm just answering back, sir. Citation అడిగారు కదా ఇందాక కూలింగ్ పీరియడ్ waived off అని.
Please give me the citation, madam, if you have got.
Amardeep Singh versus Harvinder Kaur.
Amardeep.
Just a minute, ma'am.
Amardeep Singh versus Harvinder Kaur.
అదే నా దగ్గర citation ఉంది. Don't worry.
Madam, one thing is this. As far as family court cases are concerned, I shun family court cases because simple reason is the institution of marriage is being spoiled because of these divorces and all.
I know, I do.
There are other reasons, madam, please. This is not the time to discuss on court.
But the highest paying litigation is family court cases.
Queue kuda akkade ekku undi. Queue kuda akkade ekku undi, madam. Cinema ticket కొట్టుకున్నాడు.
Madam, you got the citation exactly, madam, which AR and which.
Yes, sir. As far as my concern is correct, sir.
I'll ask my colleague to note down, madam.
Please send it across in the chat box so that it will be useful for everyone.
Sure, we'll do, Andy.
Thank you.
I think you're well versed with Family Courts Act.
That's awesome.
Right, Vasantrao garu.
6 months cooling period citation CA number 11158 of 2017. Amardeep Singh versus Captain Kaur.
CA
online availability ఉంది sir.
We'll just check up, sir.
Sir, one point of regarding.
వసంతరావు గారు చెప్పండి.
Sir, any group is there? Please add my number, sir.
గ్రూప్ ఉంది సార్. నా నెంబర్ రాసుకోండి సార్. 8919640157. ప్లీజ్ పింగ్ మీ ఆన్ మై వాట్సాప్.
Okay.
8919640157.
Okay, I have written, sir. I already have written.
ఆ నెంబర్ కి నాకు పింగ్ చేస్తే నేను వసంతరావు గారు మీకు నేను ఐ విల్ సెండ్ యూ ద లింక్.
Okay, sir.
రైట్. శ్రీరామ్ చంద్రమూర్తి, యు హావ్ ఎనీ డౌట్ మోర్?
Sir, 1998 సార్ 1998 గిఫ్ట్ డీడ్ ఎగ్జిక్యూట్ చేశారు. డోనర్ డోనీ 2 సంతకాలు ఉండాలి అని చెప్పారు కదా సార్ మీరు. అయితే ఓన్లీ డోనర్ సంతకాలే ఉన్నాయి సార్ అందులో. డోనీ సంతకం లేదు, ఎవరైతే తీసుకున్నారో వాళ్ళ సంతకం లేదు, కానీ వాళ్ళు పొసెషన్ లో ఉన్నారు ఇప్పుడు. 1998
that saves, but one thing, if it is questioned, perhaps you will be in trouble.
So the gift deed valid అవుతుందా sir?
Definitely valid, sir. It can be looked into for all purposes because possession has been given, mutation has been done, everything has been done. If it is not done, then the problem. Right, sir.
అందులో ధోని రిసీవర్ అంటే ధోని వాళ్ళ సంతకం లేదు కదా సార్ అందులో.
లేకపోయినా నడుస్తుందండి, but the law requirement of law is this, that both have to sign. Offer and acceptance.
Sir, any more questions? Can we wind up for today? Rakesh, Mr. Rakesh, please. Mr. Rakesh, please unmute.
Hello.
Please.
Sir,
yes, sir.
good evening, sir.
Good evening.
Hello.
Yes, good evening.
Sir, I'm from Vijayawada, sir.
Yes.
Sir, ఇప్పుడు ఫస్ట్ భార్య హిందూ సక్సెషన్ యాక్ట్ ప్రకారం ఫస్ట్ భార్య చనిపోతే he will be married another woman, sir.
Right.
తర్వాత తనకి ఓన్లీ వన్ డాటర్ సార్.
ఎవరికి సార్?
తర్వాత సెకండ్
ఫస్ట్ భార్యకి
ఫస్ట్ గారు అవును సార్. తర్వాత వాళ్ళ ఫాదర్ సెకండ్ మ్యారేజ్ కనుక చేసుకుంటే అది సెకండ్ వైఫ్ కి అంతగాని సెకండ్ వైఫ్ గాని తన పిల్లలు కానీ వెళ్తుందా సార్?
వస్తుందండి, ఈక్వల్ గా వస్తుంది. బికాస్ the first wife is not alive, the first wife's daughter gets it, and the second wife's progenies, and the second wife also gets it.
సార్ ఇది అది డాక్యుమెంట్స్ ఓన్లీ వాళ్ళ వైఫ్ పేరు మీద ఉంటే ఇట్ విల్ ఆల్సో బి ట్రాన్స్ఫరబుల్ సార్.
ఇప్పుడు వైఫ్ పేరు మీద ఉంటే కనుక దేర్ ఇస్ ఎ పాసిబిలిటీ ఈవెన్ దట్ ఓన్లీ దట్ షీ హస్ డన్ ఎనీ విల్ ఏమైనా రాసుందా?
లేదు సార్, నో విల్ సార్.
సో ఫస్ట్ లీగల్ హెయిర్ వచ్చేసి హస్బెండ్, దెన్ అగైన్ ఇట్ గో టు ద డాటర్ ఆల్సో.
Progenies.
Okay.
Any more questions?
He will marry to another woman. We also equal share, sir.
Everdi?
That lady also gets a share, sir.
Second wife, you mean to say that?
Okay, sir.
Right.
Okay, thank you, sir.
Any questions? Can we wind up for today, or any more questions you have still to ask? You can go ahead.
Mortgages.
All right. Thank you very much. Sir, Sriram Chandramurthy garu cheppandi.
Phone number sir 8919640 tarvata sir 157. Thank you, sir.
Thank you, sir. Any more questions? Rakesh, still you have a hands up? Okay, any questions more? All right, thank you very much. We'll wind up for today. See you tomorrow again.
Thank you.